Vietnam is one of the fastest growing economies in Southeast Asia. Its dynamic market, competitive labor force, and improving infrastructure have attracted thousands of foreign investors. But beyond the surface of contracts, invoices, and trade agreements lies a growing challenge: corporate debt default. While many foreign investors focus on market expansion and growth, very few prepare for one of the most common but under-discussed risks: getting paid. Debt recovery in Vietnam is not just a legal matter, it's a strategic exercise. Unlike in some Western jurisdictions where judgments are swiftly enforced, Vietnam's system is layered with procedural formalities, administrative steps, and enforcement barriers. Even with a clear contract and default, creditors must navigate a maze of documentation, bilingual requirements, local court expectations, and the civil judgment enforcement process. And if the debtor is a Vietnamese company with strong local connections, the process becomes even more complex without in-country legal representation. Most corporate debts in Vietnam arise not from fraud, but from poor cash flow management, internal shareholder disputes, sudden insolvency, or unresolved quality or contract terms. Delays in delivery, disagreements on price adjustments, or even changes in project scope often become excuses for non-payment. Foreign companies often misunderstand these as temporary issues. In reality, they are often signs of deeper financial instability. By the time legal steps are considered, the debtor may already be preparing to wind down, restructure, or quietly exit the market. Vietnamese law offers multiple legal mechanisms for debt recovery. The process often begins with a demand letter, a formal bilingual notification that outlines the legal claim and payment obligation. If this fails, the creditor can initiate civil litigation or, if the contract includes it, commercial arbitration. Under certain conditions, creditors can request asset freezing, initiate travel bans against the legal representative, or file bankruptcy motions. However, timing and precision are critical. A weakly drafted letter or procedural error can derail the entire case. Foreign investors often rely on internal legal teams or external advisors from their home country. But the reality is, without a Vietnam-based legal partner who understands local courts, language, debtor behavior, and enforcement practices, debt recovery becomes an uphill battle. Enforcement in Vietnam is decentralized. Local enforcement agencies have their own timelines and capacity limits. Successfully navigating this requires persistence, legal experience, and local reputation. This is where legal partnerships become more than representation, they become strategy execution. At LTS Law, we bring 2 decades of real-world debt recovery experience for foreign companies in Vietnam. Our team is bilingual, business-oriented, and fully embedded in the local legal environment. We have worked with FDI companies from Taiwan, Korea, Singapore, Japan, and the EU on debt matters ranging from $100,000 to multi-million-dollar commercial disputes. We don't just file cases, we analyze each situation to maximize recovery. Whether through negotiation, mediation, arbitration, or litigation, our goal is not to make a legal point, it is to get your money back. One client, a Japanese industrial supplier, had gone unpaid for over 8 months after delivering materials worth nearly $700,000. They had sent emails, reminders, and even consulted a non-specialist local lawyer who failed to trigger any response. Once LTS Law took over, we conducted an immediate asset search, discovered the debtor had recently pledged property to another creditor, and filed a pre-litigation notice alongside informal negotiation backed by legal grounds. Within 4 weeks, the debtor agreed to a structured payment plan under enforceable terms. The client not only recovered funds but avoided court entirely. If you're an investor or business owner operating in Vietnam, debt recovery planning should not begin when things go wrong. It should be embedded into your contracts, monitored through credit terms, and supported by local legal expertise. Build response timelines into your deals. Establish escalation protocols. And most importantly, act early. Silence from a debtor is a strategy, they are buying time. You should be buying leverage. Vietnam remains a highly promising destination for foreign investment. But like any market, legal risk is part of the equation. Don't let unpaid invoices undermine your business. Whether you're preparing for investment, managing contracts, or already facing a payment issue, talk to LTS Law. We combine legal precision, commercial insight, and tactical enforcement to help foreign investors protect their interests and recover what they are owed. Visit lts.com.vn to learn more or request a private consultation with our debt recovery team.